Right, I reflect we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. As was the case in the first phase of the trial, the attorneys have an opportunity to give a closing statement to you to give you their analysis of the case and why they feel a particular verdict in terms of penalty is or is not justified. Again, the statements of the attorneys are not evidence. If anything they say is different from the actual evidence, then of course you have to base your decision on the evidence, not the attorney's statements. Again, you may take notes on the closing statements of the attorneys if you wish to. If you do take notes on the closing statements, you should clearly label those notes as closing statements, so later when you're looking back over your notes, there will not be any confusion as to what was closing statements of the attorneys versus actual evidence. And with that, Mr. Hines, you may give your closing statement.
Thank you. Good morning, ladies and gentlemen. When a family of 4 vanishes off the face of the earth, when a family of 4 is murdered, it tears a hole in the fabric of society. It tears a hole that must be mended so that the families and society can move forward knowing that there was some resolution to why they were brutally murdered. And in the state of California, that's the one opportunity that we put forth to jurors to make that decision. And that decision is between the penalties of death and life in prison without the possibility of parole. It is such a daunting decision that has to be made that it is one that is rightfully put to members of society to rectify that torn fabric of society. As the judge just read to you, your job in returning a judgment of death, each of you individually, each of you decide what you believe the appropriate penalty is. And you must decide that, determining whether or not the aggravating circumstances outweigh the mitigating circumstances in such a substantial manner to make death the appropriate verdict. In reaching your decision, you must consider and weigh those factors, each of you individually. And if you find that there is no evidence of a particular factor, you can disregard that factor. And as Ms. Rodriguez told you in the beginning, there's A through K of factors. And she told you in the beginning that some of those you may or may not hear evidence of. And now that you've heard the entire guilt phase, and now that you've heard the entire penalty phase evidence, there are several of those factors from that entire record you heard no evidence of. You heard no evidence of violent criminal activity, prior felony convictions, any type of extreme mental or emotional disturbance, or that the victim participated in a homicidal act, or that there was some moral justification, or that the defendant acted under extreme duress or substantial domination of another, or was impaired, or his capacity was impaired due to mental disease or intoxication, or that he was an accomplice with a minor level of participation. And really, the evidence leaves you to weigh 3 factors: the circumstances of the offense, the defendant's age, and what's called factor K. Any other factor, any other piece of evidence, any other feeling or emotion that you believe could mitigate the defendant's culpability in this case and mitigate his punishment. When we talk about age, that can be either a mitigating or an aggravating factor. If someone is so youthful and impetuous and impulsive, that can mitigate their culpability and mitigate the severity of punishment a jury decides to give them. On the other hand, if the person is of an older age, of a decent intelligence, and has a way in the world, a knowledge of the world, that could be aggravating, because what you can say and what you can weigh from that fact is that they knew better, that they knew the consequences of their actions. They knew the impact that their actions would have on society. In this case, you have a 52-year-old defendant as of February 2010, when all of the events in this case happened. Think about what an average person of 52 years has. Use your common sense. They know right from wrong. They've probably been raised that way from childhood to know right from wrong. Common sense would tell you that. Common sense would tell you that once you learn to get your driver's license, you learn not to speed and not to run stop signs. Over 52 years, a person should learn what society expects, what society deems right, and what society deems wrong. And at some point, we should expect as a society that a person of 52 years can conform their behavior to those rules, to those expectations. In this case, ladies and gentlemen, the defendant's age is an aggravating factor. This is a person who was a businessman, who interacted with other people, who had a relationship with Joseph in a business sense and a personal sense. He had children. That is a person one with their common sense would expect would operate in a society knowing right from wrong, knowing the impact their actions would have on others. And think about that. That was even mentioned by Catherine Jarvis in that visit with him, or that phone call with him, talking about what his conduct towards others does. He was brutally aware of that. When we talk about the circumstances of the offense, factor A, we talk about a lot of different things, and it can be things that you heard in the guilt phase that you base your guilty verdicts on, and it can be extrapolations from that evidence that you may not have thought of or may not have considered, or maybe were not even allowed to consider as part of the guilt determination. Because when we talk about the circumstances of the offenses and the gravity of them, that becomes a much bigger world. It becomes a much bigger world that involves other facts, other people, and even other emotions. So I briefly want to review with you some things from the guilt phase that are important to your determination of the circumstance of the offense when determining punishment. One of that, again, is the means, the motive, and opportunity the defendant had in committing the crimes that you have convicted him of. And we're going to talk a little bit about things that you may not have thought of, or maybe you did, that make the circumstances of this offense so much more aggravating than just 4 murders. So when we talked about means initially, we talked about someone who had the tools capable of carrying out the crime. Think of his profession. Think about his construction experience, his mining experience. He had a truck capable of transporting them that could be used as a murder vehicle. He had a familiarity with the victim, their homes, and their animals. And I made this point to you in guilt phase closing about the importance of that. And Ms. Rodriguez highlighted that even more. There was no damage to a door or a window to forced entry. That pointed to someone came into that house willingly, knowingly, acceptingly. Who would have known that that night of February 4th, the McStay family was letting a killer in their front door or in through their garage? Who could have seen that coming? That is someone they had had a business and friendship relationship with for a number of years. Think about the kids. The kids that know the defendant, have been around the defendant, have seen him around the house. Granted, only 3 and 4 years old. But what cognitive skills do they have to recognize, oh, that's Dad's business partner. Oh, that's the guy who comes around and talks waterfalls. That's the guy that always has pipes or designs. That's the person who we ate pizza with. Then there was Summer. Summer holds an interesting role in this, in that it was clear and abundant from the testimony you heard through the guilt phase from MacGyver and Michael and Susan and others, that she not only was the protective mother of this family, but she clearly did not like the defendant and clearly could have been a motivating factor to sideline him from the relationship with Joe. That familiarity with the home, the victims, and the animals gave the defendant an insight into carrying out his crimes that is more personal. This isn't a stranger who kicked in the door. This is someone who walked in. That is a circumstance that makes this crime even more horrific. And of course, he had time to accomplish it, as you saw from the phone records. And he was familiar with areas such as where the bodies were buried. He also had a motive. And we talked a lot about that motive in the initial guilt phase closing, but I want to put some other aspects to that. We talked about erasing the debt, that $42,000 debt that started the chain of events on February 1st with that email from Joseph. That some could say is crushing. That he was really the only person benefiting from the forged checks that were cashed. That there were only the forged checks that were made out to him and his financial situation at the time. Remember, his financial relationship with Joseph in October of 2009 drastically changed. His percentage, his payout dropped drastically. He did not want to be sidelined. That motive, where David Cicada, Metro Sheet Metal, or others were being looked at to replace him to do the jobs that maybe he thought he was the only one who could do them.
Objection, arguing facts, not evidence. Move to straight.
Overall.
Admonish.
How offended would you be as a person being replaced? How would it be showing up to your office and all of a sudden there's a new nameplate at your desk? That type of personal hurt and that personal motivation that drives a person ultimately to kill is an aggravating factor that may not be common in just a random door kick robbery murder by a stranger. He can keep the business and he can prevent that gravy train from derailing, and he cannot be reported for theft and forgery. But I want you to think about something else when we talk about motive. And this may not have entered your mind when you heard the evidence and you heard the arguments previously. What was the defendant's motive for committing these crimes, these murders, when you look at each individual victim? It may not have crossed your mind that that motive would be completely different as to each of them. That motive for Joe, was it solely money? Was it really the ultimate of business disputes that ends in the most horrific way? But that would not have been his motive for Summer. What is the motive for Summer? Is it hatred for a strong-willed, outspoken woman who is even willing to criticize how he eats pizza at the table? Is it that strong-willed woman who's very protective of her kids around a person that's not a member of the family? Is it that strong-willed, outspoken person who is maybe interfering with his business relationship, with his gravy train? That becomes a very personal motive. Then there's the kids, Gianni and Joe Jr., Chubba. What possible motive can a human being have to murder a 4-year-old and a 3-year-old? What possible motive? Are they the only people left in that house after killing Joseph and Summer that could identify him? That's simplistic to look at. Or is it cold, callous, collateral damage? And if we're talking that it's cold, callous, collateral damage, then it's evil. What line must be crossed, ladies and gentlemen, to take the life of a defenseless 4-year-old and a defenseless 3-year-old? What line in our society, in our laws, in our human interactions with each other must be crossed to take their lives? There is no motive that can be ascribed to the killer of a 4-year-old and a 3-year-old that passes muster. And then, of course, there was his opportunity to commit the crimes, to forge the checks on the 1st, the 2nd, the 5th, and the 8th. Time to commit the murder on the 4th. His time to clean up after the murder, where he is no sign of making contact with other civilization during that time, or at least on his phone or via the witnesses you heard from, and a chance to move evidence to a familiar area. Reminding you that that was 8 miles as the crow flies from his sister's house in Oro Grande. His brother lived in Hesperia, and there's no explanation why his phone was pinging off those towers on February 6th. All of those circumstances of this offense.
Your Honor, that's a burden shifting onto the defense and has to admonish.
Overruled.
The evidence before you as to those basic circumstances of the offense you've already used to determine his guilt. There's one aspect, though, of circumstances and gravity of the offense that really should not have played a factor in that determination of guilt, but it should really play a factor here, and that is the brutality of the crime. When we talk about murder, we talk about murder in really plain, cold language. Did a person die? And by which manner or method did they die? But here we get to talk about more than that. Here we talk about what it must have been like to sustain those injuries. What were the nature of those injuries? And how they were inflicted on a particular person. And remember, the circumstances that were not determined by law enforcement or the victims or the victim's family or even the prosecutors or even the defense attorneys, the circumstances this case sets in were not determined by any of them. They were determined by the defendant. The fact that the remains sat in a grave for 3 years, 9 months, 7 days, undisturbed, except for animal activity and weather, created a lack of forensic evidence. The fact that they went unreported, unnoticed, as missing for 8, 9, 10 days leaves us with little forensic evidence in the home, and you saw that. That leaves a lot of unanswered questions. But the one thing we learned about these crimes and their brutality was from the remains that were found. So when we talk about Joseph, remember how he was described as a person. Forgiving, generous, loving, would give the shirt off his back. That's how that person was described. But remember that person in context of the circumstances of the offense. All of this was in light of repeated tales of the defendant's failings as a business partner. Messed up projects like Levine and Provecho. Fonseca notifying him of the diversion of funds and equipment. Cicada telling him about, well, you can continue to pay him, we're doing most of the work. Still a forgiving, generous individual in light of all that. So despite all of that, the defendant kept taking advantage of Joseph, forging checks, relying on him for emergency funds, for rent and other purposes, all to be found buried in a grave 3 years, 9 months, 7 days later. But look at the injuries. You can even see one in that initial photograph, which is the gaping hole in the back of his skull as he lays in that grave. The massive force of impact that must have occurred to shatter a human skull that severely. Something we didn't talk a lot about when you heard from Dr. Shangshri or Dr. Gray. Think of the force that it would take with that sledgehammer. Think of the personal involvement. This is not a shooting from 30, 40, 50 yards away. You're up close and personal with this person. A person that you have a business relationship and a friendship with. That has come crashing down and has driven you out of greed and selfishness to confront him in such a violent manner, face to face. That person who was a giving, compassionate person. The force that was needed to break his leg. That goes above and beyond what was really necessary. If you even assume that it was necessary. Think about Summer. Again, 3 years, 9 months, 7 days in a grave. That's her skull. Reduced to how many pieces? Held together by dirt and mud and soil in a grave for 3 years, 9 months, 7 days. Only to be pieced together by an anthropologist in a corner to try to determine the cause of death. Think of the up-close and personal, blunt force that had to be used to cause that damage. That is some rage. That is some anger. That's just not a killing. That's a pummeling. So hard to fracture her jaw in 2 places. But think about Summer in context of those injuries like we did Joseph. An outspoken woman, nurturing yet protective. Now you can think about something else. That familiar face that would have been let in that door on the night of February 4th, since it wasn't kicked in and no windows were broken, that turns into a monster of destruction. What would a mother's instinct be? Who does she save first? Joe? G? Chubba? As we told you in the beginning, we can't answer a lot of questions because of 3 years, 9 months, and 7 days passing and not having a lot of forensic evidence. What exactly happened in the house that night, no one can tell you. Neither us, nor the defense, no law enforcement, not even a psychic. But what we can tell you is that we know from the evidence that she was that outspoken, strong, nurturing, and protective mother and wife that would probably have fought for the life of her kids and her husband, only to be shattered into dozens of pieces. Then there's Gianni. 4 years old, crop of hair like his dad. His skull also shattered into numerous pieces. The brutal violence on a 4-year-old really needs no more discussion. And then there's Jay, 3 years old. And again, from circumstances beyond anyone's control, all we had left was a few scattered bones. But we saw from that blunt force that he would have inflicted on the right side of the head of the skull above his right eye, causing that fracture that you've seen in the photographs. An up-close, personal, and brutal assault on a 3-year-old who just wanted to dig up dinosaurs. Those circumstances, ladies and gentlemen, warrant a finding of death. That fabric of society must be mended when these 4 are taken from the face of the earth for those reasons that I've outlined. The last factor is factor K. Factor K has been referred to in some senses as the kitchen sink factor. You can consider anything. Anything that possibly could mitigate the gravity of the defendant's acts and crimes. There may be some evidence you could glean from the testimony of his daughter Taylor or Miss Jarvis as to their relationships, their family, and his business practices. And you may have some sympathy for those pieces of evidence. But remember, like anything in this case, you can't take them in isolation. Your job as a jury is to weigh those, and weigh those in the context of all of the other factors and evidence. None of anything that can be said about the defendant, his business practices, or what you can glean from the evidence that is in the record lessens the gravity of this offense. Nothing lessens the gravity of this offense. The circumstances of taking and brutally murdering a 3-year-old and a 4-year-old alone are so egregious that there's little on this earth that could minimize that gravity. You could simply show mercy. And they may ask you for that. Show mercy. What mercy was shown to Gianni? What mercy was shown to Joseph Jr.? Let alone Summer and Joseph. To receive mercy, you should give mercy. The actions of the defendant for the crimes of which he's been committed deserve no mercy. Last, when talking about the circumstance of the offense and factor K, something the judge read to you about lingering doubt. What is lingering doubt? More than likely, the defense is going to stand up here and ask you to second guess your verdicts. This is not truly an opportunity to relitigate factual issues that you've already determined in rendering your guilty verdict. But this is to call into question those resolutions that you came to. So when you talk about lingering doubt, you must remember your convictions were appropriate. Counsel's going to ask you to doubt that judgment, doubt your wisdom, doubt your common sense. When you convicted the defendant of murder, there was no doubt. You made the right decision to convict because you believed it was proved beyond a reasonable doubt. Counsel may point to the lack of forensic evidence, the lack of a crime scene, the unanswered questions. But remember why those exist. Who was in control of any evidence that was left behind after their murders? Who hid those bodies in a remote location where they sat undetected for 3 years, 9 months, 7 days? Counsel will point to the DNA evidence from the graves that they proffered and argue to you that there's these 3 unknown profiles. They're not profiles, ladies and gentlemen. They were the assumptions, the inferences, and guesses of an algorithm to fill in the blanks where it did not actually see physical DNA. And at one loci alone, it could be up to 11 different possible contributors. That should not leave any lingering doubt. Remember, the defendant sits before you as a convicted murderer. You each individually found him guilty of 4 counts of first-degree murder. You each individually found true the multiple murder special circumstance. You base that on a means, a motive, an opportunity, and the collective weight of the evidence that was presented to you of a man who covered his tracks, his greed, and his violent reaction. Someone who distanced himself from the law enforcement investigation from the minute it started. Remember, they had to track him down. And a man who lied to investigators. Remember, when you rendered that verdict, the judge or the clerk Madam Clerk, asked you each individually. And you each answered yes. Juror number 1, is that your verdict? Yes. Number 2, yes. Number 3, yes. And so forth and so on. This was not a collective yes. This was an individual yes. But, despite all of that, the defense will say there's some lingering doubt that should make you question the appropriateness of a death verdict. But I want you to think of something else. Think about the lingering doubt that the defendant left for 3 years, 9 months, and 7 days. Think about the lingering doubt to Susan Blake, Mike McStay, Tracy Russell, Patrick McStay, all of the family members. Think about the lingering doubt for every unanswered phone call. Think about the lingering doubt for every unanswered email that Susan Blake sent for a year. Think about the lingering doubt of a call from law enforcement to give an update, wondering if that's going to finally be the end of this. Think about every time the phone rang for 3 years, 9 months, and 7 days. There was no lingering doubt in your verdict when you said yes. The only lingering doubt that was left in this case was by the defendant and his actions. Remember, there is no lingering doubt.
You were the last person he saw.
I'm definitely the last person he saw.
So again, I leave you with that weighing process that you must undergo, each individually, to then return collectively the appropriate judgment of death. To remember that that substantial comparison of the aggravating and mitigating circumstances, that the aggravating is so substantial that it leaves you really with only one just choice. Remember, really, when you're left with circumstances in this case, you're left with the circumstances of the offense and the defendant's age. And alone, the circumstances of the offense, the brutality of the crime, the motive for the crime, and all of the totality of that evidence that you saw justifies only one verdict, and that is death. The death penalty is an appropriate sentence, punishment for this defendant. The gravity of the offense so substantially outweighs any possible mitigation, any possible mercy you could show him, that the only true and just outcome is death. And now I'm going to leave the floor to Mr. Dougherty to discuss one other aspect of this case that we have not covered yet, but I have a feeling the judge is going to let you go to lunch first.
Yes, well, it's about noon. We'll go ahead and take our noon recess at this time till 1:30 this afternoon. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case, including not discussing anything about any of the witnesses' testimony or arguments, and we'll see everyone back at 1:30.